So is there anybody in the room that currently has a will? Ooh, I'm impressed. I usually find about 10%. Yeah. Yes, policing is really bad too. Emergency services, it's really bad. People don't understand what's going to happen to your estate and your wishes in the event that you don't have one. So what happens today is I'm going to talk about power of attorneys, but I'm going to talk differently. This isn't a pitch for you. What I'm trying to do is educate you on what that document can do. And there are 3, by the way. Most people only know of 2. The power of that document and the mistakes that you can make where they end up on my desk. Right now I've got about 20 power of attorney investigations ongoing with just me for the region. And if you fail to express your wishes appropriately while you're capable mind, while you're with us, you're probably going to fail to do the same thing when you're no longer with us. And of course, that's when your wishes are very important, because there's no opportunity for you to express them other than that document. So, is there anybody that have a power of attorney for personal care? Awesome. Anybody have one for continuing power of attorney for property? You get the whole package. Same lawyer, same time? Cool. So what I'm going to do, it's kind of a bit of an icebreaker for you, so if you'd be kind enough just to pass them on down the line there. I'm going to ask you to trust me and have some faith in me. Not because I'm a police officer, just because I'm telling you to have some trust and faith in me. It's a perfect opportunity, if you do not know the person beside you, to say hello in a second. Is there anybody in the room that's kind of under the weather right now, under the influence of any alcohol or anything like that? Anybody in the room under the age of 18? Is there anybody in the room that might question their capacity as you and I would know them on a regular day? Yes, it's Monday. That doesn't count. Is there anybody? All is good? Awesome. Is there anybody in the room that's married with someone else? Your partner's beside you? No? Good. That's good. So you're all capable mind. There's nobody here related to someone else. Awesome. You're all over the 18 and nobody's under the influence. Great. Would you be kind enough to do me a favor? On that bag where it says put your name, would you be kind enough to put your name there for me? Remember, you're trusting me and you've got a lot of faith in me. Once you've done that, be kind enough to introduce yourself to 2 strangers in the room and ask them to sign that paper bag anywhere they want. Awesome. So everybody in the room has a paper bag. They've got a pen. They put their name on that bag, and they have the signature of 2 other individuals. Kinda, hopefully. So here's the most important part of that, is that you just basically produced a power of attorney, believe it or not. It's almost that simple. Because if you listen to what I said at the beginning, you have to be over the age of 18. You have to be of capable mind. Can't be under the influence. Okay? You have to be here because you want to, not because you're forced to. I hope everybody's here for that reason. Okay? And who witnesses you signing that document, or putting your name to that document, must not be related to you, also over the age of 18. It's almost that simple. So here's the hard part. Before you leave, I'm going to ask you to take your wallet out, put it in the bag, and I'll be at the door at the end if you'd be kind enough to pass it to me. Because, folks, that's a power of attorney. It's almost that simple. It can be on any document, and according to statute, it can be in any form. That's why I picked the bag. Really, because I'm hoping you put your wallet in there. But I haven't got anybody to do that yet, but I've got a lot of people who are prepared to sign documents. Just to give you an idea, this particular book I have right here is full of power of attorney documents that were produced by lawyers, no offense intended to lawyers, and they're all bad. As simple as they didn't bother putting the client's name in the first line. And the bank's been working on it for 7 years. It's where the name is supposed to go is the capital letters N-A-M-E. Okay, anyway. So there's a few things at the back you saw as we talked today. You're welcome to take any of it with you. I will make reference to some of it. That sheet that you will see that looks kind of like this, it has 2 sides to it. Okay, on one side is the grantor. You're going to learn who that is. On the other side is the attorney, and you're going to learn about that. That's responsibilities. in accordance with the rules and regulations that are out there. It's available in French, Dari, and Tamil. I'm working on trying to get it in other languages. I don't have a budget, so I do a lot of smoothing. So, the most important thing with power of attorney documents, although it's called power of attorney, it's not about power, it's totally about responsibility. And it's your responsibility to be logical in your layout, and it's the person who you appoint the responsibility to look after you. They must walk in your shoes, and we're going to be talking about that. Very important you realize I in no way am a lawyer. I do not profess to be one. I have taken courses on this stuff at Osgoode Hall just to understand the civil law side of things. So on wills, will drafting, elder law. Over the last year, I've been studying that kind of stuff just to get better at it. I am in no way an expert. Just a one man's opinion. And when I speak, I'm not expressing the interests of Durham Regional Police or speaking on behalf. They're coming from me. Okay? If you want to challenge me, please do, because I learn as I go on this. It's quite simple when you break it down, but you'll probably walk away today going, it's quite complicated, because it's been made complicated over the times. Okay? If I happen to scare you today, I will not apologize. In fact, I'll be happy, because that's my intent, is to scare you so that you really think about what it is you're about to produce when you produce these documents. And if you've already produced them, I'm hoping that you will leave here later today, when you're having your coffee at dinner time tonight, you pull the documents out and take a look at them and see if the quality is there with what you intended it to be. So if I've scared you into doing that, I kind of reached my aim. I use the PowerPoint just to follow. You're welcome to follow it. Listen to me. I did give you the sheets. You make whatever notes. I consider the power of attorney document being the most important document you will ever sign. Your will being the second most. Of course, power of attorney documents are why you're with us. Your will is why you're no longer with us. Thus, I put them in category 1, category 2. I also think that the power of attorney document is probably the most dangerous document you ever produce. And the reason why I say that is I defy anybody in this room. You don't want to give me up your wallet, but would you give me a blank check? But that's what a power of attorney, that's what makes it so dangerous. Takes a lot of faith and trust. I said that to you at the beginning. If you're really interested, there's a whole bunch of books involved. Okay? That's just some of the stuff. That's just on capacity, which we're going to get to. That entire book is on the word capacity and the elements to it. As I spoke to you already, to author a power of attorney document over the age of 18, a resident of Ontario. That's very important. If you take up residency in another province, your documents from a province of Ontario are no longer valid. Your will is the same category. If you take up residency. If you're a snowbird, that's fine, because your address is not changing. But if you are taking up residency, you move to BC, you're free to do so in Canada. It's one of the beautiful things about our country. You can get up, move anywhere you want. Just remember, when you move to that particular province or territory, you must have documentation in line with their rules and regulations, because all of this is state litigation and power of attorney is provincial. It is not federally regulated. Also, if you move to the States or Europe later on in life, you must have one in their jurisdiction, because you must follow their rules. Their rules are not the same as ours. Okay, so always keep that in mind. That'll come up also later when you're trying to pick someone for your executor and attorney. Capable mind will be a discussion. Whole bunch of different things involved in this. Mental Health Act, Healthcare Consent Act, Declaration of Death Act. There is an actual act that determines when you and I have passed legally. So what we're going to look for is, first of all, some definitions. The first one is what a power of attorney document is all about. You're going to hear me speak of grantor and donor. I apologize, I don't like the last term donor. Nobody's donating anything, but the legislation reads donor. And attorney, which has nothing to do with a member of the bar, nothing to do with a lawyer, as we traditionally know him, Old English term. And donee, again, that's in the legislation. I personally don't like that term, but we can only work with what we got. So has anybody heard of a general power attorney? Yeah? Okay, so all power of attorney is a fancy word up there. Is that what you're basically doing is you're asking someone or other parties to administer your property, your finances, on behalf of you at a time when you're not able to. Notice I didn't say capable, when you're not able to. And there's a reason for it. There are 3, most people only have 2. Everybody in this room would probably consider having a general. And the importance of that general, we'll get into. But first of all, let's go for terminology. Donor. Your donor, again, apologize, that's the person who the document's about. That's you. As is the grantor. Again, that's you. The easiest way to remember is that you're granting someone else authority to speak on your behalf. Again, there's no donation going on here. A donee is the person you've appointed. Attorney is also that same thing. There are 2 different acts, and we're going to get into the differences in a second. And it has nothing to do with a member of the bar again. So when you're thinking of a power of attorney, it's very, very important that people go around all the time and say, I'm the power of attorney for my mom. You cannot be. It's impossible, folks. You can't be a power of attorney for anybody. A power of attorney is a document. It's the document that gives the authority for someone to act. Thus, you are either the donee or the attorney. That makes sense to people? I hear it all the time. Even lawyers say it. The last lecture I was at was a lawyer speaking who's been in this business for a very long time. And that was the first thing to the other lawyers that he was speaking to was stop calling it, telling people you're the power of attorney. Because you can't be. It's physically impossible. When you hear me speak of grantor and donor, think of the same person. Attorney and donee, think of the same person. Easiest way to remember that. The first one then is the General Power Attorney Act. The General Power Attorney Act is for you and I. It can be anything business or individual-wise, but it's very, very specific. It is going to be for a defined period of time, specific task, and most important is it ceases to be important or exist when you are past or become incapable mind. So what happens with a general power attorney? I have what's called a capacity line here. I call it the line in the sand. So the general is over here, where you and I all sit today, even though it is Monday. Okay? We're all on the capable side of the line. Okay? We have our capacities. To give you an example, I did 2 tours in the Middle East as a police officer. I did a general power attorney because a lawyer friend of mine recommended before I did the first tour, asked me if I had one. I had no idea what she was talking about. The night before, quickly produced one, and thank goodness I did. The restriction upon it was a couple things. First and foremost, it came into play when I stepped off the soil of Canada. It remained in play until I stepped back onto the soil of Canada. It turned out very helpful because I was gone for 14 months when I originally thought I was only going to be 5. So if I had dated it, it probably would have expired while I was away. So if you're going to go travel the world, for example, you reach that point in your life, you're able to do that, and away you go, bucket list item. You might want to consider the same thing. You could use a date, of course, to restrict it. And it's going to be very specific to what a person can do. So you can say the administration of my bank account at X financial institution. That is all they're able to do, though. That's it. You've limited to what you have written down. So if it comes to selling of your house, they can't do it. They can't sell the dog. Okay? Your boat's still going to be in the driveway when you get home, hopefully, or otherwise it's staff, because they can't sell it. You haven't given them any authority outside that very specific. Why is that helpful, though? As I've already indicated, if you're traveling for a long time, very, very important to have one. We see sometimes with the seniors, though, is that they're physically they're not able to make it to a financial institution, and they insist on that one-to-one taking place. So they're turned to their son, their daughter, whomever, the stranger, the contractor, and ask them. And they use the power of attorney document known as a continuing power of attorney. Well, as you're going to find out, that one's based on incapable mind. The individual just physically can't make it. Doesn't say they're incapable of making decisions and being part of the process. So if you have a general power of attorney going to the financial institution, you're able to speak on behalf of. If you've ever seen a power of attorney document produced by most of the financial institutions, they're quoting general. So be very careful when you're looking at them. Again, key element to that is the moment you become incapable mentally, it ceases to be in play. Fully intended while you're on this side of the line, when you're physically might be incapable, but you're still with us mentally wise. Very few people actually have a general. Again, you could produce that document today and just tuck it away for a later date. Just remember whatever restriction when you say when it kicks in, you're very specific on when that is. Does that make sense? So that's over here. This is Monday morning. That's you and I on a regular basis, hopefully. It's a great document. Seldom used, though, unfortunately. The internet is making it less requirement for it, but there's a lot of seniors that today still insist on doing the visits, the one-to-one. They won't use the internet. As a fraud investigator, I tend to support some of the reasons why they don't, be honest with you. I don't do internet banking for one. Again, it's a very helpful document. And it permits you to assist someone else, if that's what you're doing, without using the wrong document before the financial institution. Any questions on that? Clear as mud? All right. Something very important to say with the general, and holds true with the other power attorneys, it does not give you the authority to change somebody's will. Right? Out of all of this, there is absolutely no authority to change the will. Again, just to refresh your memory, it becomes invalid when the person becomes mentally incapable, they pass. Also, if they revoke it, or is expired based on the time frame that you gave them. Okay? Very important to make sure that you understand that time frame and your restrictions.
I actually have a quick question.
Please.
General powers of attorney, is that something that you can just draw easily by yourself?
Yes.
A template on the internet?
Yeah. In fact, I give you a template in the back.
Because I know the other two powers of attorney are much more complicated and require lawyers. But
They don't require lawyers. None of this has to be done before a lawyer, nor does your will. That's why I did the paper bag. You could actually take that paper bag, put general power of attorney on the top of it,
my pen
and add a couple more things to it, and that becomes your power of attorney. It could also be your last will and testament. A last dying proclamation is still authorized as a last will and testament, by the way. So you do not have to go to a lawyer.
But isn't there a concern then that you might have a phrase in there or a clause that invalidates it?
It's not so much the invalidated. You might be missing something that would assist in the execution of it. Okay?
But templates would help you with
Templates do, but be careful of templates because the internet is full of them, and there's a lot of internet garbage in, garbage out. You will get a lot of garbage. And some of the very simple things is page numbering. I can look at the document and have no idea how many pages are involved. Often it doesn't even give me page 1, page 2. I ask that you put page 1 of, and actually so that when I'm looking at one page, I know that there's other pages coming.
So there's nothing missing.
Nothing missing. More importantly, nothing's being changed. A simple thing is putting the person's name at the top of every page. Now you sit back and go, well, that's simple. Well, it really isn't, because when I look at them, if the name's there, because like I told you, there's one that I have that's, the name isn't even there, but if the name on every page will help me to, and other police officers or anybody looking at this, to understand that this belongs with the other pages and this is Mrs. Smith's document.
Or numbering clauses, that sort of
Numbering clauses. Simple thing is initials on every page. Now you go rent a car, for example, and what do they do with the car? Your initial here, initial here, initial here. You don't want that initial here? Okay, you want that initial here. Why are they doing that? So they can come back later and prove a number of things. But it goes back to the authenticity of you signing that document. Many times all we ever do is get the last page. So, and I've had it where the last page holds the signatures and the pages before it's all the narrative. We have absolutely no idea if that signature page belongs with the narrative. I've also had it where a couple of those pages have changed. So just a simple thing, an initial on every page, including the signature page. Now you go, why the signature page? Because I want to know what your initials look like. Your signature and your initials are different. Okay? Again, unfortunately, you will find that because there is no standard out there, those simple things are not done. So what I would like to suggest to you folks is, as a means of protecting yourself, this is your document. You own it. The only thing you have to do is some basic thing, identify who you are, identify who your attorneys are, and make sure that it's signed appropriately. Okay? But the contents is your content. Okay? So insist that if you do it before your friends, you can come up with it as you want. But if you're going to a lawyer, insist that you do that. I know a couple of lawyers that will do that. Unfortunately, there's a whole bunch that do not do that. Okay? So when it comes, sorry, what a long-winded answer to that one, eh? But there is an example for you for a general back there. I'll give you an example for continuing. I don't give you an example for personal care. Again, from the policing side of things, it's not so important, but we are going to talk about it. Same thought holds true, though. And I will suggest to you to carry that thought through to your last will and testament. Because again, I don't see page numbering. I don't see the name on every page. Does one assume? Give you an idea, state litigation right now, folks, has taken over divorce court. There are more challenges in the state litigation court than there are divorces and family law issues right now. When I last checked with the University Avenue Courthouse in Toronto, in October I was last there, they were booking courtrooms to 2022. And why is that? It's all about the dollar bill. It's all about money. So the weaker your document, the easier it is to challenge. The tougher documents become tougher challenge. So there is a trend right now. They've started suing lawyers more. The lawsuits from 2017 was $6 million in payouts. They challenged the lawyer because they can't challenge the doctor or the document itself. You never want your legacy to become the implosion of your family, nor the implosion of your intents. Because this is an expression of your wishes. This is all about you. There's absolutely nobody else in the room at that time or when that document's being administered that counts. Absolutely nobody. This is the one time you can stand up and say, this is me. Because you're the only one that counts. Okay? Power of attorney document states. So let's talk about the power of attorney for personal care. Anybody have one? I believe there was a few over here, right? Yeah? Okay. I'd almost suggest it's probably one of the most misused ones. You will hear people talk about power of attorney for well-being. You hear them use the phrase for health. And sometimes you'll hear living will. It is not a living will, but you can make it kind of like a living will. A living will is an expression of your wishes in the event that, unfortunately, you've reached a time in your life where things aren't going so well for you. And maybe you can't express those. But here, you can use this document to do that for you. There's a lot of controversy or conversation over what narrative you should be using. I'm going to show you one in a minute, written by the legal people, but some lawyers don't like using it, but we'll get there in a sec. So power of attorney for personal care covers 6 categories. That's them. Now you sit back and go, well, what do I care about my hygiene? I'm at a time in life, what do I care if I look all pretty and dapper and wearing the aftershave and shaving? Well, that reflects actually back onto your health. It has a major effect on your health and your ultimate well-being. You go for a few days without making sure that your body's clean, that will affect your health. Shelter is where you're going to live. Home versus a institution. Safety is more towards the protection of you as an individual. For example, safety in your own home. You leave the stove on all the time. You leave the gas in the fireplace on, but there's no flame burning. Those kind of things. Your home you have mobility issues, but there's an open staircase, that kind of stuff. So there's a variety of different things that come into safety. When it comes to whether or not you should have a personal care, power of attorney for personal care, that is an absolute personal decision. But I'm going to take you down some of the avenues to things to consider, and then you decide whether it works for you or not. 6 categories, though. Remember those 6. There's a test later. It comes up later. That's under the Substitute Decisions Act. If you really have problems sleeping, folks, feel free to read that document. I assume you're familiar with it.
I have it right here, actually.
There you
It's
go.
all my favorite parts of it,
Yeah, your parts of it, because the actual act is substantially thicker. If you're ever looking at it, the Substitute Decisions Act is, again, a provincial act. It covers a number of different elements. It covers you and I when we are able.
I'm writing on it.
There you go. It covers you and I when we are incapable. It will cover off what happens to adults, anybody over the age of 18, when the system, the government has taken over governance of your life. Okay, when they become your I'm losing the term all of a sudden, guardian. And it also, there's an element to it relative to when you pass, which we'll get into a little bit when I talk about the public guardian, trustee. The power of attorney document for personal care, unlike the other documents. So a general is very specific, and it's in play during that time frame that you specified. The one for personal care is event triggered. So it could be in play today and not be in play tomorrow. And a lot of people forget that. They realize, they come back and say, well, mom's got Alzheimer's. And by the way, Alzheimer's does not equate to incapacity, nor does dementia. Those are symptoms, unfortunately, lead to other issues, but they do not have anything to do with capacity per se. It's event triggered. And that event can be a simple, I shouldn't say simple, but that event can be a need to go in the hospital for an extended stay. You're in there during that period of time, and there's going to be a period where the person is under the influence, if you would, because there's an operation taking place and the drug isn't going to allow them to come out and be back to being Mary. As you know, it's going to take a couple of days for it to wear off. Or Mary's going to take some time to get back to the Mary that we know. So what happens when they say event triggered is, this is your one event. So Mary's in the hospital, she has that operation in 48, 72, whatever time frame it is. Mary isn't able to speak on behalf. The medical personnel turn to Mary, she cannot give them a clear direction. They will turn to whoever she appointed as the attorney. That attorney can now speak on behalf of Mary. When Mary comes back and is able to articulate her wishes, that attorney now goes back in the corner. So for example, if you happen to be the daughter of Mary, you step up, you speak on behalf of, because of the power of attorney document appoints you as the attorney to speak. When Mary is back to being Mary, you go back to being the daughter. Does that make sense? Okay. So initially, you're not speaking as the daughter, you're talking as the attorney, which you're going to find has more power than the daughter does, by the way. Okay. Time goes by, another event occurs, and she is no longer in a position to speak for whatever reason. The document kicks in again. And then when she is back, it ceases. It is not your opportunity to get even with your big brother that used to, pull your hair too much when you were growing up, and now I'm going to say you can't go see mom. It doesn't give you the authority to restrict access to mom. But I see it all the time, and I hear about it. Okay? The attorney said. It's not directly related to the house. Okay? Then the attorney has no say on who comes and visits. But it's misused often. The other thing is people naturally assume that because it started, it continues. Remember, of course, you're supposedly over this side of the line, the incapable side of the line. Do you need one? The alternative to not having one is the Health Care Consent Act. But you're going to find out in a sec here that it only handles one element of those 6 elements that I showed you. Those 6 elements that I showed you. Okay? It's very important that if you as an individual decide that you want assistance later in life in all 6, then you should have a power of attorney for personal care. If you're not going to worry about it, that's your choice. You can only use that document, folks, when it comes to someone's personal care. You cannot use that document to speak about the management of their finances, sell their house, or anything else. It's strictly personal care in the 6 categories. Ooh, there we go. What will happen is if you don't have one, the medical profession will look for what's called an SDM. Now, I don't know if anybody's ever heard that term around the halls, but the hospitals and stuff, but they're looking for the substitute decision maker, or an SDM. If you notice when you work down the list, guardian is a court-appointed individual. So, of course, the court has the number 1 say, right? Because that's the highest level. The attorney is second. Remember how I was saying that you go from being the daughter to the attorney and back to being the daughter, that the title of attorney has more strength, more authority? That's where it is, because the attorney is number 2 for personal care when it comes to your health decisions. So just imagine Mary's in the hospital, the medical practitioner is turned to Mary, they need informed consent, they need to speak about some sort of process that needs an answer to. Well, there's a couple of things that they have to explain, of course, to Mary is what is it we're going to do and what's the effect of what it is we're going to do. And here's an alternative, maybe, and what's the effect of that alternative. So Mary's given a couple options. You, as Mary's attorney, only have the same options. You can't invent something else. You can't go, wow, we want. There is one option that Mary also had that they will often not bring up, and that's called a second opinion. But whatever is brought forward to Mary during that time frame is the only things you can speak of. You can't just pull something out of the sky and say, well, no. The next part is the Representative Consent Capacity Board. We're not going to get too worried about that. Spouses come number 4. I've actually seen it where spouses are not an attorney. And the medical profession will actually tell the spouse to leave the room to talk to the attorney because they can't. The document said the only one you're allowed to talk to is my attorney. Problematic for some people, not so for others. You sit back and go, well, why wouldn't I make my spouse my attorney? What if your spouse is a very emotional individual that has that long tie with you, been there for 30, 40 years? Congratulations if that's the case, by the way. 30, 40 years together, okay? They're not going to want to say, I need to pull the plug. The wish of John was not to be in this state. Therefore, I, as his attorney, speaking on behalf of John, ask that you, if they're an emotional individual or they've got that strong tie, they may not have the strength to do that. But that's what John wanted, not what Mary wanted. Okay? This is Mary's opportunity to speak. This is John speaking through Mary. Does that make sense? Okay? So that's why you will sometimes see the spouses. Otherwise, sometimes they're just afraid to pull the plug a little too early. I don't know. The kids come into there, they're number 5. Believe it or not, they're down the list. Then you start getting into parents with right to access, that's the divorce issue. And it works its way down. At the bottom of the list, number 9 is the Office of Public Guardian and Trustee. We'll talk a bit more about them in a little bit. There is a 10th that's not on the list. Ma'am, I'm sure you know what the 10th is. What's the responsibility of all medical practitioners?
The doctor?
All doctors, all nurses, what do? They have to do everything they can
In the person's best interest?
in person's best interest. Yeah. Yeah. I always pronounce it wrong, but it's the Hippocratic oath. I pronounce that always wrong. But it's their oath that they take. So you may wish not to continue. You may wish that they do not resuscitate you. But if you haven't produced something to support that, they must take those steps. And they will take every step they can. It's an awesome system. It's your fail-safe, right? So if you don't produce a power of attorney for personal care and you're happy with that happening, you're good. Remember, though, they're only talking healthcare. There's still 5 other categories that they will not cover off for you without having that document. This is one I actually took off a document. There's from some of the classes I took. By the way, that run-on sentence isn't my run-on sentence. Was actually on a document. Heroic measures. Some people define it as, don't do CPR on me. Don't take the extra steps to keep me going. In the legal medical world, they find that to be a very dangerous term. So they ask that you don't use it. So I ask you is to write out what exactly you expect to be done. Now, does that mean you can cover off every event? Probably not, unless you're a medical practitioner. But what does it do for you? It lets you sit back. Now, this is a hard thing you got to have a conversation with yourself. That's a hard conversation because most people don't want to think that. You sit back and go, in the event that this happens to me, what would I like to be seen done for me? We don't want to think that. So you might have to have that tea on a few different days. You know, do a little gardening or go for a walk or something in between. Something to break that thought process up. But put some serious thought into it. I wouldn't suggest a run-on sentence. But the more detail you provide as an expression of your wish, what have you done ultimately, folks? You've told the medical practitioners exactly what it is you're looking for. But the medical practitioners are going to be told by whom? Most likely not you. Your representative, your attorney. So now you've asked someone to do certain things for your benefit. Do you think that's a lot of stress and pressure on them? If it's just verbalized, then does it open the door for someone to challenge them? You know, Mom said that in the event of, this is what she wanted. Yeah, well, I sat with Mom over tea, coffee the other day, or whatever, and this is what she told me. And she told me this only a couple of days ago. Well, you say she told me that 2 months ago. So she changed her mind. Now you've got a person who is supposed to do what is right for that individual, Mom, and they're caught. Because if they make that decision based on, they're being challenged. Remember I told you about the legacy becoming an implosion of your family? There's a fine example of where your family is going to pick up different corners. Right? And it can turn into a real mess. So the clearer you are in your document, the more logical you are in your document. Not only are you telling the attorney exactly what you want, so they can turn to the medical profession and say, here, read it. They can turn to the sister, the brother, here, read it. You know, the shoemaker, anybody else that asks, they can show them that this isn't me speaking, this is speaking. And all I'm doing is acting on behalf of. Because this is all about them. It has nothing to do with me. So back off, leave me alone, and let me do what I got to do. It's your document. The other one that is very, very important and is misused on a daily basis It's called a continuing power attorney. It's covered on the Substitute Decisions Act as well. Its intent is the intent of the Substitute Decisions Act, which is when I am incapable, I need someone to speak on my behalf. What happens is that people produce this document. It becomes a legal document, a bearer instrument at the moment they sign it, permitting the attorney to act upon it at that time, unless you limit it. And I would suggest to everyone in the room that's got one right now, you're probably, if you look closely at it, it's in play right now as we speak. In the wrong hands of the wrong person. So you need to take some time and think about when it is you want them to do it. And more importantly, don't give it to them. So it's covered under the Substitute Decisions Act, and it handles property. So where personal care took care of your health, your safety, your hygiene, where you're going to live, this takes care of everything else about you. So in essence, what you see in the mirror is personal care. What you're wearing, what you drove to work in, where you're living, all the toys that you own, your real estate, the dog in the backyard is your property. That document covers everything else about your life. So imagine for a second if your intent to sign it today is so that later in life when you need that protection and you need somebody to assist you, that if they used it or misused it and took away all your finances, do you think it's going to affect your health, your well-being? Oh yeah. There's a study out of the U.S. from the American Texas branch of the American Protection Agency. I don't know if anybody realizes, but in the U.S. they have an adult protection service, which is like CS in Canada for children. We do not have an equivalent. They have it by state, and it's a federal agency. Anybody over the age of 18 has nothing to do with age. It's vulnerability. The Texas state element of that organization did a study. Their preliminary findings was there are 7 categories of elder abuse. No need to go through them, but primary 2, most obvious, physical and financial. Makes sense, right? Especially financial can affect the physical. They found in initial studies, they're doing more studies, direct correlation between financial abuse, physical abuse, and death within 5 years. Recently, long ago, but a very long investigation that I did involving different elements. You might have heard about it, the Reverend from PI. Anybody hear about that one? Okay, but what happens there is that the one of the victims there identified, she actually passed within 3 years of being victimized, of identified to her. So, direct correlation. I take your money away, I'm going to affect your health and your well-being. There's just no way around it. And you work so hard to get to that point in life where you should feel safe. If you fail to do this document right, you give them a blank check. Or you give me your wallet on the way out the door. I'm not giving it up, no. Can't fault me for trying. Okay? It permits you to deal with every element of a person's life except make a new last will and testament. So I can invest in your name into the stock market. I can sell your house. I can sell your car. I can take all your clothing and donate it. Very, very powerful document. It's all supposed to be done with your best interests. However, what's it look like? Takes many, many different faces, folks. You go on the internet, you will see a whole variety of them. Be careful too. Sometimes when you're looking on the internet, you got to check the province that it's coming out of. Okay. Out of BC, they call it enduring power of attorney. We do not have such a thing in Ontario. There is no enduring portion of this. But in BC, that's what they call it. So if you're going to take it off the internet, be very, very careful. I did give you the sample of, and what it is the primary ones that lawyers use, but it's been modified with my modifications on there. As I mentioned, the initials, the name at the top of every page, page numbering, and a few other things. But when you're looking at, kind of looks like that. I don't expect you to be able to see it off the screen, of course, but I'm going to break it down for you. And why I'm doing that? Because this is the one I find that's most dangerous for most people. This is where they err, and because of those errors, they end up losing their finances. If you lose your finances, I already said, it can affect your health, your well-being, and your future. First and foremost, right off the top, before you sign that document, you must be aware of certain things. The sheet that I gave you that says grantor, must be aware of, reflects these things. The key thing I always find very, very important here is G. I find G very, very interesting. You have to appreciate the fact that there's a possibility the attorney may misuse their authority, i.e. they can rip you off. You're going to sign a document knowing that there's a potential for someone to rip me off. Does that make sense? I'm going to sign a document that permits someone to rip me off. If it makes sense, I'm happy to accept your blank check. You have to know that by law, believe it or not.
So how do you stop that?
How do you stop that? You make your document that much better. You have to put quality into the document to take away their ability to rip you off. The problem is I find most of the documents don't do that, and it's too easy to rip you off because they don't. Because they use that canned answer, canned approach to everybody. Just because yours needs to read this way, this lady's can be completely different with different narratives, different controls that she wishes versus you. Okay? But if you don't take that time, if you just grab it off the internet or do the one that's produced for you from a law office, etc., if you don't understand what it's going to do for you or what it may not do for you, you could be hurting yourself. And that's why we're breaking it down now. So first and foremost, right off the top, by the way, that's your name, not capital N-A-M-E in brackets. That's where you put your name. Folks, very, very important, and it holds true again for last wills and testament. And as you hear me speaking today, a lot of the stuff I bring up for power attorney documents holds true with the last will and testament. Same type of thought process should go into both. They're just totally different purposes. Of course, power attorney is why we're here. The state is speaking when you're not. It speaks for you. Your legal name, folks. If you have somewhere along the line changed your name to make it easier, or you're known as Johnny, okay, your real name is Jonathan, but everybody calls you Johnny. Your legal name is Jonathan. That's the name that should appear. If you do go by a pet name or some version of your name, though, do the legal name, and then in brackets behind it going also known as. Okay, don't write AKA. You're assuming then that people understand what you mean. Write also known as, okay, or known as, and you can use your pet name behind you. That way there's no confusion as to this is the person that this document's really all about. Because everybody knew him as John. Nobody knew him that Jonathan, right? And you meet lots of people that way, especially those with some very long names, combination of letters, and they want to shorten it down to make it easier for people, you know. So, very important that your legal name goes in there. Again, holds true in your will as well. The next part of it is where you are going to decide, why does that do that? You're going to appoint someone, or more than someone, to work on your behalf. People ask this all the time. Do I pick one? Do I pick two? Do I pick three? I've actually seen 5. 5 different people on one document. You want 5 people to come up with one decision based on what you wished. Good luck. So, do you go with 1? Do you go with 2? Or do you go with 3? Anybody got thoughts on 3? Tiebreaker, there you go. Okay, so imagine you're in a situation in your life, and remember this holds true for power of attorney for personal care as it does a continuing power of attorney for property, but you can also put this and apply it to last will and testament. The difference being is you pick one executor, or two executors, or three people to be executor. So we got three. Parents in the room? More than one kid? 2 kids? 3 kids? Awesome. You put 3 kids in the kitchen and tell them to make a decision what to have for lunch. Come back 5 minutes later, probably got half the fridge out on the table because they all made their own decision on what they were going to, didn't care about you. They just decided this is what they were going to eat out of the 3 of them. What was the question though? I need one decision off the 3 of you, right? Or the alternatively, sometimes you'll find that the 2 gang up on the 1. Okay, the 1 is over here, might be seen as the favorite, the one that helped out mom all the time. So by picking that 1, the other 2 might get a little jealous, cause problems. Do you want them warring over what they want at a time when you need someone to look after you and make a decision relative to you? I'll suggest to you probably not. I'm going to suggest that 3 is not a good idea. 1, let's go back to the blank check. A power of attorney document, continuing power of attorney for personal care, in a way, as with power of attorney for personal care and a continuing power of attorney for property. Or in a way, a blank check. Would you write one check to one person's name and allow them to go do whatever they want with it? You're not giving any checks and balances in there, are you? You're giving them a carte blanche to do whatever they want. You're hoping that they're going to do everything for you, but there's another side to that though, folks. If you are responsible for someone else under an attorney as an attorney right now, you'll find what I'm talking about to be true. It can be extremely challenging on you. You are stepping into the life of someone else. Yes, it might only be mom or dad. It could be your sister. It could be your brother. It could be your neighbor. Person in the church congregation with you. But you're stepping into their shoes. So you must maintain your life, all the stresses and everything that you're doing in your life, and now you're going to pick up theirs. All the stresses, the challenges. You're going to support them. There's a lot of work involved. You're busy enough in your own life, now you're picking up a second life. A lot of people that get involved in this will find that it's extremely tiring, if not just stressful. So if you stick it all onto one person's shoulders, you're asking for an awful lot. They may not even be able to take a simple thing as a holiday like the rest of us and go away for a week because they've got to worry about mom for that week while they're gone. And I guarantee you, even if they're able to find someone to help mom during that week, what are they going to be thinking about? Mom. It won't be a holiday. What's the other thing that happens when you give everything to one person? There's no real accountability. You're hoping there is. I call it dangling of the carrot. You open that door. I'm not saying that everybody will step in it, but what about the other side of it? The court of public opinion. What's been happening the last couple of years? Constantly, all these allegations against people. There was just last couple of, I think it was last week, there was an actor that actually challenged the allegations in a paper in England, and he won. Because he said, no, I did not do what you wrote in this newspaper. Everybody looked at him as being a bad guy. He won in court, saying that paper had no basis to anything they said. But few people probably heard that portion of it. They heard that portion big time. So remember, you got one person who's now responsible for you. You might have thought that that was the same person that should be doing personal care. What if you put the executorship on their shoulders as well? So now they've had the opportunity to take care of you and make decisions relative to your care. They're over here managing all your finances. And then when you pass, they're over here as the one doing the books. For not only here while you're alive, but also when you're gone. Remember what I said about the courts? The challenges? It's all the dollar bill. Can you imagine that at your wake, at your passing, another member comes up and says, you know what, you took 20 bucks from Mom. I go, no, I didn't. I've done everything in favor of Mom. I've worked hard. Very good chance they probably did. But what'd you just do to them? You absolutely just probably destroyed that individual, created a fight, and your legacy now becomes an implosion of your family. I don't know if anybody wants that. You put a lot of burden on one person. So, I'm sure you figured it out, but I will suggest to you that you probably want to use two. Two attorneys. And not necessarily the same two on health as for property. Hopefully, the one on your property isn't your executor, by the way. And why is that? Because, again, realizing that most people are really good. But unfortunately, sometimes when you dangle the carrot, people will bite. But if they know that along the line they're going to be held accountable, somebody might see what I've done later on, you're usually going to keep them toeing the line. And again, they go back to do the best things for you. So if you pick two, which you're always 99% of the time I see in the document, it'll say severally and jointly. People realize what severally means? All by yourself. So I picked Jane, and I picked Rob. And I said, I want Jane and Rob because I think it's a good idea to have two people, but I'm letting them work alone. Well, why'd I pick two? Jane's going this way, maybe. Rob's going that way. Or what often happens is, Rob says, I don't want to get involved. I'd rather watch the sports channel. And lets everything happen to Jane, thinking that he's safe. From a law perspective, he isn't, by the way. He's still legally responsible. But a lot of times, they will allow the other person to do everything. This often happens, too, is if Rob's in another province, or is it quite a large distance away from the individual, they will say, you take care of it. You live in Oshawa, you live in Whitby. It's too far for me to come. Well, then maybe mom or dad should never appointed Rob in the first place, because that should be part of your thinking process. I will suggest to you folks that the best thing to do is always jointly. If nothing else, it shares the stress and the pressures of the whole exercise. It causes them to work together with your best interests. But each one of those knows that the other person is watching. Limited temptation. Doesn't guarantee the two will rip you off together, but when they have to work jointly. Now, people say, what happens if Jane were to not want to do it anymore? Well, Jane has to resign. It's a legal document that has to be signed. Again, can be done off the internet in her own home, but it still has to be produced. So when you get to the alternate, the substitute, before I get that, I'll break substitute down in a second. But there's a couple things to keep in mind here, folks, when you are picking a person. Before you produce the document, before you go all that trouble, especially if you've hired a lawyer, have that conversation with the person you're appointing as your attorney, and have that conversation with your executor. This is my wishes. In the event that I am no longer capable, I've been dean, I want you to pull the plug. In the event that I must leave my home, although I want to stay here for as long as possible, in the event I have to leave my home and move into an institution, I need you to sell my home, put that money in the bank to pay for my institution. I want. Hard conversation, eh? You're just laying out doomsday to family members. Or it could be interpreted as doomsday to them. It's going to be rough for you. It's going to be probably rougher on them because you've come to grips with it. They haven't. So bake that favorite cake or pie or whatever, or go buy that favorite dessert, whatever they like. Sit down with them, but prepare to have that conversation over a period of time. But if they turn to you and say, listen, Mom, I can't do this, there's no way. I don't have the strength, or I'm too busy looking after my own 6 kids, or I just can't do it. Without a reason. Respect that. They just did you the world of good. They just told you up front, no matter what happens to you, I can't be the one that you need to fully rely on to take care of you. They've done it before you've spent money before a lawyer, but more importantly, they've admitted to you, I'm the wrong one. Please go find someone else. They've done you a big favor. The worst thing you can do is say, you're my attorney. I need you to, what are you talking about? I'm not your attorney. What's an attorney? What do you want me? No way. I'm on holidays next week, you know? Or, even worse, somebody passes and the will appears and they're all of a sudden now the executor with no knowledge of anything prior to that. Yeah, talk about the freight train coming down the highway. You know, just not a good situation for you. So please, don't give them surprises. You're the one that's going to lose if you do. Substitutes. Folks, the purpose behind it is in the event that the primary can't, I'd like somebody else to do it for me. So don't put the primary as a substitute. I have that. It's a redundant statement. And again, it's not protecting you. So imagine, let's go back to our example with Jane and Rob. Jane decides that she doesn't want to go play anymore. For whatever reason, she cannot be involved in this. So she resigns. So what you can do in substitute is rather than go down and say somebody else's name, you actually put, I don't know, throw a name at me, Sue, okay? And Rob, or you can do Jane and Sue. Don't just list Sue. Because if you list Sue alone, in the event that something happens here, Sue's working alone. You're back to the same problem you were at the beginning. And don't assume that everybody understands that you want Rob and Sue to work together if Jane goes. Say it. Absolutely. This is your document. Spell it out. In the event that Jane no longer can, for a variety of reasons, there is a text in there that's a can text. I want Sue and I want Rob to work jointly. The same thing holds true if there's a passing, by the way. Okay, the document is not invalidated if one of them were pass on you. Okay, but in that case, I want these two folks to work together. I'm not leaving it up to Rob anymore, because then it's back to single person, right? Which defeats my intent of protecting myself. So lay it out. State exactly who it is you want them to be. Does that make sense? Anybody have any questions on that part? It's a challenge of some people, though. They say, but I don't have anybody to pick. I've had people say, try to get me to tell them who. I can't tell you. I can tell you from your last will and testament side of things, you can hire a trustee to be your executor upon passing. Most financial institutions do have a trustee element to them. So if you're not sure, you go to your bank, ask them. You can set it up with them. There is a fee that is involved. I believe by statute right now it's 3% of the overall value of the estate. That's the maximum. They can't rob you blind, take 50% and give the other 50 to the dog. They can't do it. They're by law, by statute, I believe it's currently 3%. So they won't deal with the average individual unless you've got some assets there, of course, because they're not going to they'll be doing it for free, and it's a business. But there is trustees that can help you out in the event that you don't have someone you can think of. When it comes to personal care, when it comes to your continued power of attorney, don't pick your pharmacist. Got one of those right now. Yeah. I don't know who to suggest. Your neighbor might be the best person. Your best friend could be that person. Do have a substitute though, folks, because if you don't and the other person, whoever you appointed, resigns, passes, then you're stuck. You have no coverage. You've got nothing. If you have nothing, what happens to you? Well, if you're cleaned incapable, that's where the government comes in. Big Brother, Office of Public Guardian Trustee. Great organization, folks. They truly are. They go through great efforts to be the last resort. They do not step in just because. They do have a threshold they must reach, but they go through a lot of effort to find alternative options available to them. They will reach out to family. They find long-lost family, believe it or not, the people we don't know of. I've had 8 individuals become guardians under the public guardian in the last 3 years. We're working on up to 11 right now. If it's sitting with me, there's problems. I'd rather not be here. Okay. They are a great organization. Their authority comes under the Substitute Decisions Act. If you're ever looking at the Office of Public Guardian, just to break it down for you, obviously office is part of the provincial government. Guardian is adult guardianship, anybody over the age of 18. Okay. Age is not a limiting factor. People at various ages have trust accounts, for example, because of insurance payouts, because they've been injured, that kind of stuff. Guardianship occurs at any age. The trustee portion of that is in 2 ways. If they're guardian of someone, then there's a trust element looking after their finances. But there are also the people that get involved if you pass without a will. You passed intestate. I think if interstate highway, intestate, there's no highway involved in it, but if you pass without a will, this is the organization that by law must be advised. They will come in, look at your assets. They will determine based on laws who gets what, if anybody gets anything. People say they're evil. No, they're not. Okay? They will work to the letter of the law, though, which may not be your wishes. But nobody knows your wishes because you didn't take the time to produce the will to tell people what you wanted. A will, people, can be a simple matter of saying, I bequest everything I own to, and sign it. 2 witnesses. Okay? But if you don't, public guardian can kick in. Just a sideline for you. There you go. This is where it gets into trouble. Anybody got any thoughts on what incapable means?
Well, I guess the problem is, who's going to deem you incapable?
Yeah.
Is it going to be a doctor? Is it going to be CCAC? Or is it going to be you?
Correct. Could be a complete stranger. But you just used very important terminology. You said deemed. That has legal implications. The Canadian standard across the board, everybody in Canada is of capable mind unless proven otherwise. The responsibility to prove you otherwise is someone else's, not you. So I don't have to prove that I'm capable of mind, thank goodness. It's probably a fight I'd lose, but anyway. It's not my responsibility to prove that I am capable of thinking. And you sit back and you go, so give you an analogy. It's a cold day outside, and I step outside, I'm wearing a nice coat, and I decide to take my coat off and give it to another person. You may go, oh, that's a nice gesture, but he's crazy, he's going to freeze. Do we care what you think? You know, it'd be nice, the fact that you say, oh, you did a nice gesture, but the latter part of that is, oh, he's crazy, he's going to freeze. Your opinion means nothing, folks. Absolutely nothing. And we hear all the time, well, mom's got dementia. She's not capable. Or mom, guess what? I give you that in a wooden nickel. you're left with the wooden nickel. Your opinion means nothing. Doctors' opinions, by the way, mean nothing by law, unless you write it to say that the doctor opinion has bearing. If you leave it as it is now, and it probably says, when I am incapable of making decisions relative to the management of my property in accordance with the Substitute Decisions Act, you have just opened yourself up to a world of interesting times. And why is that? Because the word incapable. Nobody's opinion is a part of it, and deeming of an individual is taking somebody's civil rights away from them. You've taken their civil liberties. So imagine when it comes to the management of my money, you decide what you're going to do with your money. You're going to buy lunch, you're going to go to the grocery store, you're going to go buy coffee or make your coffee. You're going to do this versus that. But now somebody else is going to make that decision on your behalf. That's a civil liberty. When we're talking relative to the documents, it's only mental capacity, it's not physical. Some people forget that too. Mom's not capable of getting up and going to the bank, therefore she's not capable. Really? Based on whose opinion? Here's your wooden nickel. Okay? It doesn't matter. So let's take a look at capacity. So, as this lady said, it depends on who's doing it. She used the word deemed. It has a legal connotation to it. By the way, Central East Lynn cannot deem you. They have no legal authority to deem you, as you'll find out. Nobody got any thoughts other than that?
Court system?
Court system, definitely. Definitely. That's where the guardianship portion of the Office of Public Guardian come in. Or you could go to the court as a private citizen and make a case that whomever you're dealing with hasn't got the capacity. You must prove that, by the way. Okay? You just can't walk in and say Martin's crazy. They're going to agree with you, but they're not going to take my civil liberties away. Okay? So you need to bring in the evidence to support that. So it doesn't have to be the public guardian office that does it, but courts is always one. I love this. I take you back to your days of school in English class, or French if that was your language, or whatever it was. The English teacher asked you to define a word. Were you allowed to use the word in the definition? The government does. What does it mean? Well, when you're incapable, it means you're mentally incapable. Oh, wow. Gee, thanks, that helped. That clarified it. So let's go back to that line in the sand, folks. That's what I call it, is the line in the sand, because it's a key element of your life. So we're all over here. That's awesome. If I was rigid on where that line sits, what's going to happen for the government? Every person that steps beyond that line, by definition of the word incapable, is now the responsibility of society. Could you see that being a problem? So what they do is they will not be rigid in that definition, because that becomes a hard, fast line. And anybody that steps over it now becomes an issue. We'd have a lot of problems. It's always mental, not physical, as I've mentioned already. So that's the way the Substitute Decision Act speaks of capacity, folks. In essence, think about your time at visiting the doctors, the last time you were there. And the doctor turned to you and said, we need to put you on a medication for whatever it is. You need to know that the medication does this, but it has these effects. If you listen to the American media when they do medication, if anybody has that medication at the end of it, you know, your limbs are going to fall off, your hair's going to fall out, you're going to shrink by 6 inches. Like, why would you? The reason for it is called informed consent. They have to let you know that by doing this, this may occur. By having this surgery where I'm going to fix your hand, you potentially could, okay? That's informed consent because they need back from you that I understand what you're telling me, I understand what could happen as a consequence, and I am prepared to go through with it. That basically is what you have here under the Substitute Decisions Act when it comes to capable. An individual must have the mentality to make a decision and understand what happens in the event of, or as a result of that decision. And you may not like it, by the way. Your opinion doesn't count. The alternative to it is, if they don't make a decision, they must understand what happens if I don't make a decision. And if they understand that, they're capable mind. Interesting at times, too. If anybody's dealt with some people that do suffer from Alzheimer's and dementia, you see the time of day has a lot to do with them. Sundowning, for example, all that means is later in the day they start to diminish. They have a good day versus a bad day. It's fluid, but it isn't. So, as you mentioned, a court. Number one, Superior Court of Justice. That's guardianship. Consent Capacity Board is a review board that will look at a person who's being deemed capable or incapable, depending on the fight, and they can rule. The Ontario Mental Health Act. What happens there, folks, is anybody that's in a mental institution such as the Shores as a resident, they have been deemed for that period of time that they're in there, that their liberties are basically gone, and that they're deemed that they are no longer of capable mind. When they let them out, when the person is no longer a patient, that no longer is in play. So it's very restrictive. So I will suggest to you that the majority of us, 1 through 3, would never have that occur in our life. This is not going to happen. So here's the one that will happen, keeping in mind that you use the word when I'm incapable, and you need somebody to identify when you're incapable. That's it right there. Licensed capacitor, capacity assessor. They are a medical practitioner in the province of Ontario. They do not have to be an MD, a nurse. I've seen physiotherapists. I've seen psychiatrists with geriatric experience. It is a paid for service. $500 at the lower end of the scale, $3,000 at the high end. Per test. There are 9 tests. If you want to look what a test results look like, I put a couple examples, or I copied right out of this book for you what the report would look like. You're welcome to take a look. What happens, though, folks, is that it has to be an informed consent test of you. So as I understand it, and it could be wrong, but this is what I've been led to believe, is that come up and say, hi, sir, my name's Martin. I'm a capacity assessor. I'm licensed with the province of Ontario. I'm here to do a capacity assessment on you in the area of property. In the event that I deem that you have failed the test, this is what's going to happen. Do you agree to the test?
Not capable of making those decisions, how can they give you informed consent?
Catch-22, isn't it? Because they have to be informed consent. So depending on who you hired, they may just turn around and go, I didn't get consent, and they leave. They're still getting paid, by the way. Of course, because it's a fee for service. But you could have them leaving, where some will, depending on their experience, will research you, talk to family members, talk to people who are engaged in your life and get a better understanding, to realize if they're talking to you right now at the latter part of the day when it's not so good for you or interrupted your sleep, whatever, that's a medical world. The key thing is that you have to understand is it's a fee for service. But when you put the word incapable in your document, what you've told them is, I want this test. People don't realize what you've just done. I hope you saved some money for it. Most people haven't. And what I find is most people get upset over the amount of money that's involved in having that test done. But what you did by saying, when I am incapable of managing my property, and it goes to substitute decision, I just said, go test me. That might not have been your plan. Maybe you sit back and say, well, my doctors know me for 20 years. They know the prescription that it's on. They know my medical history. They know that this, and this. They know me on a good day. They know me on a bad day. Maybe I want my doctor to decide that. So what you do, folks, is don't put the word incapable in. Say on a written note based on the opinion of my medical practitioner. That's my instruction. As long as you put that instruction in there, people can work off of it. Because what should happen technically is that document, when they walk up to the financial institution and say, here, I am on behalf of my mom, I'm here, I'm representing her as the attorney, she appointed me under the power of attorney document, continuing power of attorney. Here's the document to prove it, and oh, by the way, here's the second document that proves the condition she implied. The problem is the financial institutions work off this. They never ask for the second part. And that's where a lot of people get into trouble. It can be anything you want it to be, but if you use the word incapable, be prepared for one of those four. It's continuing because what it says is that once it's invoked, basically from the moment you sign it until you have passed, or until you revoke it, or until you write a new one, which of course will revoke the previous. It is in play. So you could have one currently, be fully capable, and a person can be out there working in your best interest using that document. And it happens often. So how do you protect yourself from that happening? It's really simple. Don't give it to them. If they don't have it in their hands, they can't use it. But what so often happens, especially if you go to the lawyer's office, you get one produced for each attorney that's listed. Plus you'll get one. And then what you do is you get it, and then you pass it to them. Say, here, you're the attorney. Does this gentleman need to know the contents of this document? He just needs to know that I've asked that in the event of, and I tell him what the event is, I need him to step up for me. And of course we had the conversation before, so he knows it. And I tell him where it is. It's secured somewhere in my control. I'm not giving him a blank check. Your will's the same thing. Is there a reason your executor needs it while you're still up and kicking? Not one bit, folks. Absolutely no reason that your executor needs to have that document in their hand. And I'll suggest you don't give it to them because you're dangling the carrot. The potential off. Responsibilities for an attorney, by the way, now that I've mentioned the power attorney and the estate, is the attorney's responsible to know the content in general form of your will. So, and what I mean by that is if you bequeath certain things in your will to certain individuals, it's the attorney's responsibility to make sure that they maintain that so that when you pass it can be given to the appropriate person. Sports memorabilia. Okay, so the will says my favorite sports memorabilia goes to my first grandson, Johnny. The attorney can't sell the sports memorabilia. Or they can, but it has to be, they have to justify that sale and prove that there was no other option available to make sure there was enough finances to keep you going while you're alive. Otherwise, it's their job, their responsibility, their legal responsibility to make sure they maintain it so that on your passing, it's not there. But they don't need the document to do that. So what I often suggest to people is a simple way is you take that document, you stick it in an envelope. Please don't use a DRPS envelope. I stole that. You put your will inside there. All right. Who's got a pen? No. You can put your power of attorney document in there. You can put anything you want in there. Put anything you want on it. Now, if it's a will, And your executor is Will. I wouldn't put Will. Put William. Okay? But you can put anything on it that makes you happy. Okay? Anything that works. Because every time I look at that, I know that's my handwriting. But I want to make sure it's safe. Everybody's friend. If you don't have any, go to the dollar store. You can have a good time with it. The place is not a safe, by the way, for your will. Because what happens with, a safety deposit box. Because what happens with a safety deposit box is when you pass, the executor will walk up to the financial institution and say, here's the death certificate for Jane. Jane Doe has died. They go, I'm sorry to hear that. My thoughts are with you and the family. And they go, thank you very much. I need to go in the safety deposit box because the will's going in. And they go, great. So show me the will. And they go, but the will's in the safety deposit box. And they go, great, but show me the will that says you're the executor. The document, the legal document that proves what you're telling me to be true. And you go, but it's in the safety deposit box. And they go, you realize where this is going? You can stand there all day long, folks, with the key. They're not letting you in. You're going to have to go to court. So is your will in the safety deposit box as an original copy? Probably a bad idea. You could put that anywhere in your home. Keep it under your pillow. Keep it on your dresser. Better would be in a filing cabinet somewhere. As long as you don't write will, or power of attorney document. If anybody looking will not know. But you tell. I tell this gentleman my power of attorney document's there and the name Jane's on it. This is where you're going to find it. So when that event occurs, he knows exactly where to go, where I put it safely. I haven't dangled the carrot, though, because I haven't given the opportunity. I'm not calling this guy a crook in any way whatsoever, sir. But what I'm saying is I take the opportunity away from him. Okay? Take the opportunity away, you're going to win. Anybody want to try it? Get into this without me knowing?
How would you use a new envelope? Put it back in there. Write it. You would remember what your writing looked like.
It's possible at that point in time. But this thought is more, but most people are producing this of capable mind younger in their life, and then they give it out. And I can tell you, I did a case where mom did it, it went to daughter, and then daughter sold her house, and $320,000 later, the local long-term care facility wasn't getting any rent because she did a curb dump with mom, and mom was getting all her care through you and I. And what made it possible was the lawyer went, here's your copy. And what I'm saying is you take that copy away from them. It's your document. They have no need to have it in their hands. Take it from them. Better still, don't give it to them. Let them know it's there. That's very important. But there's absolutely no need for them to have that in their hands. Restrictions, you can put anything in there you wish. Good time to think about what it is. Okay? You want to say that I intend to maintain myself in my home until such time as, and at that point my home is to be sold and the money is to be put in trust to pay for me to stay. Say it. Absolutely no reason why you can't say it in there. The clearer, the more detailed you are in there, it's your document. The instructions are now to your attorney. They're to anybody reading it, and there's a less chance that there's misinterpretation of it. People usually leave that blank. When they came up with this form in 1992, they put it in there thinking people were going to put in restrictions. Perfect time for you to do it. There's just a few that they give you as slots. They're just one person's slot. You could very well say that as a doctor, medical doctor, legally able to practice in Province, Ontario. Okay, I wouldn't go for an internet doctor. But they've written a report, and it's in their opinion that I have had problems maintaining my property. That's okay, if I decided it. Or I may want a capacity assessment. I may also say, and, would be kind of redundant, but I could if I wanted. So what I've said is, my doctor can make that decision, And he's not deeming me, he's just decided that I'm not able to, for a variety of reasons. It could be the medication, for all you know. Or I go the normal system, which is on the Substitute Decision Act, the capacity assessment. Or I come up with some other thing. But it's mine. But if you say incapable, folks, you are opening yourself up. And according to law, although the financial institutions don't follow it, that's what's supposed to be happening. I.e., just because you have this in your hand, power of attorney document, doesn't mean you can act. You need this and whatever my restrictions were as well. And that together gives you the authority to act. It's effective the day you sign it, unless you say otherwise. It becomes a legal bearer instrument, same as your will. Revocation holds true for wills as well as it does for all power of attorney documents. The standard is the signing of a new one, replacement one, revokes the previous one. Okay? Automatic. It's an automatic revocation. You can also revoke by signing a document called a revocation of a power of attorney. It's just a one-page thing. But if you're doing a new one, that's what it will do. You do not have to have that line in there because common law, the way the laws of the land are, it's understood that if you produce a new one, the last one signed is the only legal one. Compensation is always a good one, folks. Can you imagine what this would be like? Yeah. Why are we doing power attorneys, folks? Why'd Mom ask you to help her out in her affairs? Protect her interests. In the interest of Mom. Hoping that Mom will be able to have a valuable life. I've just helped her along, right? Should I be making money off Mom when I'm doing it? No. So unless you put anything other than that, the statute is annually done by the provincial government. It is actually a set amount. It is currently 0.03%, okay, of any monies that are made once you take control. Not a lot of money, is it? So you got $1,000 in the account. When the take control is the attorney, that made $10. In the year that you looked after it, you can pay yourself 3 cents. Good luck getting 3 cents. No, you can't round it up, by the way, to 5. The idea is you're not supposed to make money off the deal. You're supposed to be doing it for all the right reasons. You can put a line in there if you so wish. Be careful. I've seen it where one document, personal care, said the compensation will be what we agree on with the attorney from the continuing power of attorney document, i.e. they gang up on me and take what they want. They pay themselves, whatever they feel like it. That's a blank check, okay? You want to avoid that. But if you do not put anything in, it's an automatic as per statute. And like I said, it's a legal bearer instrument the moment you witness it. So I'll give you a few other thoughts to think about your stuff. It is based on trust. Comes from the word fiduciary. You've probably heard about that term tossed around that. But all it means is somebody has a legal responsibility to look after you. They must work within your best interests. The problem I have as an investigator is I have to determine at what point your best interest is. It'd be easy if you could tell me. The problem is that most of the time I end up dealing with people who are incapable. So what happens is that they're on this side of the line. Because I need to get your story, I can't go over here. I end up only being able to look at this side of the line, the point where you are officially, legally incapable. That lady I told you was $320,000. I only charged for $74,000 because most of the money was stolen over here. She couldn't speak to me, so she couldn't tell me what the intent of her daughter having that money. Because what do people normally say when they get something from someone else? They wanted me to have it. It was a gift. Yes, Mom isn't being fed, but that boat in the driveway that Mom wanted me to have is really nice. If I can't talk to Mom, then I can't challenge that boat. But what happens when they become incapable? The fiduciary kicks in. That's a quick one for you, but something I wanted to talk to you that's most important. Anybody have in a position of attorney right now? Do you have a joint bank account with the person? You're going to change that when we're done, aren't you? How about you?
Actually, my aunt is on as joint, and I just went to the bank and produced the power of attorney for finances. So,
Okay.
yeah.
All right. So
Her name on before I went to the bank, the power of attorney form.
Okay.
Powers of attorney, my mom and I, or we became joint prior to her being
okay.
determined incapable.
And I thought it was great, because it's like, well, her name's on it, she can see everything I can do, so she's
Yeah.
not gonna accuse me of doing anything.
But do you understand what a joint bank account means?
Be responsible as well.
I check her balance every day.
But what's a joint bank account?
You can just go take money whenever they want also, first any name.
How much money can they take?
However much they want, the balance of the
Yeah.
account.
That's what people have to, most people do not understand though with joint bank accounts. Okay, it can be one person, two persons, whatever. You can have multiple people in that bank account. The money belongs to each and every person listed. They can take 100% of it without question, unless the person is deemed incapable and there's a fiduciary. But what you just did there, unfortunately, what happens right there, folks, is that this is Mom's account. And as soon as Mom put another person on her account, she just gave her money away. Was that the intent of Mom? No. Mom never intended to give her money away. What Mom said was, I need you to help me out, dearie, or whatever. I need you to help me in the event I can't. I'm not giving you my money. I might do that in my will, but I'm not giving it to you while I'm alive. And please don't take it. But as soon as you go joint account, folks, that's exactly what you've done. You get to take 100%. Now, for those who are married, I wouldn't take 100% if you happen, God forbid, divorce, because the rules are different, okay? Only take 50. But other than that, this is Mom's account. You want it to always remain Mom's account. Mom does never want to give her account away. So this is the way it should be done properly. And hopefully the law will be changed soon. You will walk into the bank. Mom's account is Mom's account. Mom says, I have a power of attorney document. Here's the original. The bank will make a photocopy of it. It'll be a continued power of attorney or general as well, folks. Works the same way. They will superimpose, if you would, the power of attorney document. And by the way, banks always call them power of attorney. They don't call them attorney for some reason. But they will list whoever the attorney is on that account. That doesn't give you automatic right to access the account, though. Because whatever that document said should be the requirement for the second portion of that, right? Like I said, capacity assessment, letter from the doctor. Mom has a bank account, a debit card, client card, call it what you want. You are not allowed to use Mom's debit card. You're not allowed to have it in your hands. You're not allowed to take it from her. And you're definitely not allowed to use it. It's actually a criminal offense. But it also breaks civil contract. So if Mom's account is the victim of a fraud, and the bank knows that someone else is using the card other than herself, the bank will know that for that to occur, they had to have the card, and you had to have the PIN. PIN was issued to Mom and Mom alone. Mom signed a contract saying that she would not give that PIN to anybody else. So Mom is now open to a potential of problems with the bank. Not always the case, but potentially. Mom's card is Mom's card. The fact that you're appointed attorney, you cannot deny Mom her property. You can't take it from you because you think she's going to lose it. She loses it, she loses it. It's hers. No different if she loses anything else. As an attorney, when you come with the second part, you get a second card. And that card will come with its own PIN. So now you're not breaching any contract with the bank. More importantly, though, folks, is that you should restrict this to a 0 daily limit on cash. Is there any reason why you would need cash? If you set it up, every bank account today has direct payments. So if mom's in a home, or their own home, wherever the house is, and needs to pay the gas bill, the water bill, the electrical bill, the telephone bill, it all can be done automatic. There's no need to cash. And very little need for checks. All that's automatic payments. And who knows how many those are. The beauty of that is you're not engaged in any of that. You just verify that every month, make sure they're okay. Mom's not getting ripped off or charged for something she shouldn't be charged for. But other than that, you're not part of that process. It just happens. The bills get paid. On this side of the fence, you might want to go to the store for a mom. Say you got to go to Shoppers Drug Mart, pick something up for her. You can use your debit card to make that purchase. If you went to the bank machine and you took $100 out of her bank account, you're now required to account for that $100, right down to the penny. But if you use the debit card, you make the purchase, it is recorded down to the penny. And you don't have to worry about the change. Because you know where the change is going, right? It's going to get mixed up with yours and it's not going to go back. But by law, you're required to account for every bit of that $100. So if you don't take any money out of the account, and you pay using the debit card, you don't have to worry about the change. But there's even a better part of it, which is even more interesting. Because with most financial institutions, you pay them a small fee. Mine's $2, because I still get my bank statement every month. I'm a fraud investigator. I pay $2 a month, and it comes in the mail to me. If there was multiple people on my account, it will show the action on my debit card. It'll show the action of the debit card of the other person. Somebody's just done the accounting for me for $2 a month. And I'm not paying the $2. The person whose account it is paying it, as it should be. But if anybody now challenges me and says, you took money from mom, well, I can't. Yeah, well, you have a debit. Yeah, but I can't take money from mom. And they go, well, prove it to me. All you have to do is take the bank statements that you've collected with the receipts attached from Shoppers, etc. It's called passing of accounts, and you show it to them. The event, unfortunately, when mom passes, and it's now taken over with the executor of the estate, they're going to ask you for all the accounting leading up to that point. Now you just have to take it as a bundle. Here it is. I just did the passing of accounts. I've done my responsibility, and it only costs $2 a month, or $3 a buck. I don't have to worry about that change and worry about balances. Most people are afraid of debits and credits, right? Why? Let somebody do it for you automatically. Let the computer do it for you automatically. And at the same time, you're not opening up the account for the potential of problems related to fraud, and you're not keeping property away from your mom or dad, whomever it is. A couple of last things I'm going to mention to you. A lot of people seem to want to do this. They go, to save my kids the trouble, I'm going to give them my house when I pass. So what I want to do, and when they say trouble, they actually mean taxes, I'm going to put them on title with me. Think that's a good idea? So mom's in her house. She plans on leaving the house to little Johnny in her will. Okay? So she says, let's go to the title office and we're going to change. We'll go to a lawyer. Doesn't cost much, and I put him on there. So now he doesn't have to pay taxes, inheritance tax. What tax do you have to pay? Capital gains, because Johnny's probably living in his own house, right? So in fact, Johnny's going to pay more in reality. So that tax becomes capital gains tax, which is higher than inheritance tax. But what else did you do that's even more problematic, folks? You just gave them ownership of your house.
You can mortgage it,
They can mortgage it. I've seen it.
potentially sell it.
They could sell it and force you out of it. But what if Johnny's relationship with his lady is not going well? And she leaves. She's going to get 25% of your home, folks. So you're sitting at 70 years old or whatever, your mortgage is paid off, a great possibility. All I'm worried about is the gardens or the flowers in the garden. And Johnny, you what? You're divorcing? Now mom has to buy back her own house
Pay off, what's her name?
to pay off what's the name? Yep. Or vice versa. So folks, although you may be saving Johnny some money, you think, in reality you won't. And the other portion of it I may offer to you is we all have to go through paying taxes, right? It happens. It's a coming of passage, because as soon as you start to work, you start paying taxes, right? It just is. Don't deny them the joy of it all. Let them have some fun with it too, because that is part of life, right? Don't shelter them from it. Yes, bequeath it in your will. That's absolutely fine. But let them have the heartaches when you're gone related to covering off the taxes, etc. And don't set yourself up for losing your home. I've had people do that. I had an elderly woman come up to me and ask me to kick him out of my house. And I went, I can't. He's on title with you. He went from creating a power attorney document to getting on title to $300,000 in mortgage. I stopped $180,000 just by 24 hours in luck. He would have mortgaged the whole house. She ended up, even though she told me she wanted to pass in her home, she ended up, the house had to be sold. She got 50% of the profits, where she should have got about $500,000. She got around $75,000, and she ended up in a home. Now, one of those were her wishes.
Can you take them back off?
No, court, because it's done through a lawyer. So now you're challenging a lawyer.
No, but if you go to the assessment office and put them on, can you go and take them off again?
She has to go with the person, and the person has to agree to it. Well, if they got into trouble with getting on title, they're not going to take themselves off title. It isn't going to happen. And for me to challenge that is almost impossible. The registry office, if I can prove it's a fraud, can pull it off. But if I know that it was the individual that actually signed those papers, it's okay, Grandma, just sign here. All's good, Grandma, I'm looking after you. We're done. And Grandma is going to lose her home. You're not doing yourself any favor, folks. Okay, bequeath whatever you want. Just don't give up ownership. Other part of that is gifting. I told you about the line in the sand. When I'm on a capable mind, you can gift anything you want, okay, as long as it's informed consent. Gifting stops the moment you become incapable. So the challenge from an investigative perspective is at what point did the person become incapable? Everything forward, there is no gifting going on, can't. So if the boat is bought after the fact, then I can do something about it. But if it was bought before, I can't ask the lady, did she intend to buy this boat? We're done. Very complicated, unfortunately. And that's how you can open yourself up to it. So there's just some things that kind of recap everything I've been talking about for the last 2 hours. I do hope that it's been a little insightful for you. You understand how to document. The reason I use the paper bag is to give you an idea. It's an illustration of exactly your life, if you would. Because just imagine everything you own fitting into the paper bag. It's not realistic, of course, but it's a collection of everything that you own short of yourself. And you give that to someone else to administer in hopes that your trust in them is worthy and that they don't. And I will suggest to you the majority of people do, but I can also tell you that there's just too much money out there right now. There is a trend, unfortunately. You don't want to be that one person that somebody looked at as a bank account. Nobody in this room is a bank account. No human being should be seen as a financial means to the end. So do protect yourself, please. I hope you found it of value. Remember that it's got nothing to do with power, it's everything to do with responsibility. I'm still waiting for somebody to try to open this without me knowing about it. No takers, eh? And may I wish you all the best.